Good afternoon and a warm welcome from Cape Town to all of you who've joined us today and to our distinguished partner, the Foundation for Human Rights, and our panelists. The Courageous Conversation program is situated within the overarching theme of our foundation titled The Courage to Heal. The program creates platforms that push for peace and social justice, harnessing moral and ethical voices locally and globally on pertinent issues. These dialogues address bold and topical issues in a critical and constructive manner. And the past social justice issues have spanned over topics such as xenophobia, climate change, gender-based violence, and especially the need for accountability for social justice on aspirational and concrete goals that the late Archbishop Tutu displayed with commitment and passion. In the case of the work of the TRC, it is widely acknowledged that the work remains incomplete and is characterized as an arena of both achievements as well as contestation. The TRC provided an important platform that exposed the unspeakable crimes, and that is the point, that these were expressed for all South Africans and the world to witness the injustices and the trauma of our past. Therefore, the Foundation has partnered with the Foundation of Human Rights and co-conceptualized today's programs as we are a co-signatory with the Foundation of Human Rights to an open call for the establishment of an independent Presidential Commission of Inquiry into the suppression regarding progress that was due regarding prosecutions of those who were denied amnesty through political interference into the work of the NPA and SAPS. It is a painful deal which was kept away from the families and their lawyers. We will be giving the floor today, therefore, to award-winning broadcast journalist and author, Lucanio Kalata. Welcome, Lucanio Kalata, who is also a social justice activist who has spent close to 2 decades pursuing justice for his father, Fort Kalata, one of the Cradock Four, anti-apartheid activist assassinated by apartheid security forces in 1984. A very special welcome to the Honourable Deputy Minister of Cooperative Governance and Traditional Affairs, Minister Thembi Nkandameng. Welcome. She is a sister of the late Nokuthala Simelane, who was abducted, tortured, and forcibly disappeared by members of the security branch of the South African Police in 1983. Welcome too to Advocate Vani, who joins us and is a practicing advocate at the Johannesburg Bar, who is representing the victims' families before South African courts in a number of apartheid-era cases. Advocate Vani brings a wealth of experience investigating and prosecuting gross human rights violations in South Africa and internationally. We're also very delighted to welcome human rights lawyer and former TRC Commissioner Yasmin Sukar, who I believe was not able to travel today, which is a considerable gain for us. My counterpart, the Executive Director of the Foundation for Human Rights, Hanif Vali, welcome Hanif, will be facilitating our courageous conversation this afternoon. And without wasting any further time, I'd like to hand over the floor to him. Over to Hanif for your opening perspectives and to lead the way with regard to this extremely important, courageous conversation today. Over to you, Hanif.
Thank you very much, Piyushi. So as Piyushi has made clear that this conversation, part of the partnership between the Desmond and Leah Tutu Legacy Foundation and the Foundation for Human Rights, is about accountability and justice. The need for the Independent Commission of Inquiry into the suppression of cases arising from the Truth and Reconciliation Commission. Now, let's just quickly deal with the context of this issue and the history of how far we've come in this matter. When we're talking about cases that came out from the TRC, the TRC law was very clear that people who were refused amnesty, or in fact, who did not apply for amnesty, could be charged. A number of cases, very important seminal cases, were forwarded to the NPA, and they were asked to prosecute in these matters. So we are trying to uphold what the law is. The law was clear, and the law has not been applied. So let's be clear that what we are doing is trying to uphold the rule of law. Secondly, clearly there was political interference, and this has been confirmed in the various high court matters by judges who heard these matters. We don't know the circumstances of the political interference. We're not sure who is responsible. There has been a lack of transparency from the executive, from the police, SAPS, and the NPA. And we have some sense of what happened through affidavits filed by people who were in high positions at the time. But we need clarity on these issues, and so do the courts. Political interference is in fact a form of state capture and is reflective of wider accountability issues in South Africa. One of the primary causes of gross violations of human rights is impunity. And we are trying to draw a line in the sand saying, no more impunity for gross violations of human rights. We want to see the rule of law applied. Now, despite the fact that there is common knowledge that there was political interference, and this we get from the various court matters that have come before the courts, always, almost without exception, at the behest of families. There's nothing that's been done by the executive, the NPA, to reassure us as citizens, us as the public, that they are capable of acting without fear and prejudice, or without us dragging them to court and insisting that they do what their duty is. In November 2021, the Minister of Justice announced an inquiry by a retired judge, and this in itself is problematic. We still don't have enough details on what this inquiry is all about, but we do know that it was envisaged as an internal inquiry, rather than as an independent commission of inquiry, which would allow for people to be subpoenaed, etc. We have invited the Minister of Justice to participate in this webinar. Unfortunately, he had other engagements and couldn't participate in this particular webinar. Why do we feel there's a need for an independent commission of inquiry? Well, firstly, we need to give answers to the citizens of this country, to the public in general. Number two, the Commission of Inquiry should be properly empowered, for example, to subpoena witnesses and obtain documentation if necessary. And number three, to allow for participation by victims and by the public. We're not asking for a rerun of the Truth and Reconciliation Commission. We are looking specifically at the lack of prosecution, in effect, from the evidence we've heard, the suppression of cases that should have been prosecuted in accordance with the law that established the Truth and Reconciliation Commission. So let this be clear. We're just asking the NPA and the SAPS to do their jobs and act in accordance with the law. Having said that, let's talk about what's going to happen today. What we're going to do is, and we welcome all four speakers. I think Piushi has already mentioned them. Yasmin Suka, Howard Vani, Lucanio Talata, and Tembi Karimeng, who's also, congratulations, Tembi is also now a deputy minister in our country. We will be recording and live streaming this webinar. We would welcome participation by participants in the form of questions that they want to ask. And we ask you to use the Q&A facility, and the questions that you will be posing will be posed to the panelists after they have all participated. Each panelist should please try and restrict themselves to between 5 and 7 minutes and not exceed this time. So let's start off now. we're starting off with Yasmin Suka. She's one of the world's leading experts in transitional justice, and she's also a human rights expert. She is presently the chairperson of the South Sudan Human Rights Commission, having been appointed by the United Nations. She has served as commissioner of the South African Truth and Reconciliation Commission, as well as the Truth and Reconciliation Commission in Sierra Leone. Yasmin Suka, you have the screen, the mic, the floor. Thank you.
Thank you, Hanif, and good afternoon to our colleagues and participants. I think it's fair to say that, in fact, when we talk about the unfinished business of the Truth Commission, we're talking about a struggle that has spanned a period of more than 23 years since the Truth Commission handed over a list of cases to the NPA for further investigation with a view to prosecution. And this was, of course, in accordance with the law that established the Truth Commission, that if you did not apply for amnesty, or if amnesty had been refused, then the law would follow its course. And so really the notion of taking up the struggle is to pursue the question of truth recovery, justice and accountability, not only for the victims and their families, but also for our society, so that we can come to grips what happened in the past with a view to ensuring that this doesn't happen again. And so it's really useful when one goes back to the parliamentary debate that took place on the, when the TRC handed over its first reports to President Mandela. One of the things he said is, we are not contemplating a general amnesty under any guise. Such an approach would go against the grain of the very process that we all agreed upon. It would undermine the culture of accountability that we seek to engender. But in fact, if you look at the actions of the different regimes that came after President Mandela, it does seem as if negates everything that he said there. So let me start with the beginning, really, when the struggle began. Already as far back as 2003, one of the relatives of one of the apartheid-era cases, that of the death of Ahmed Timur in detention, his nephew Imtiaz Kaji approached the NPA to investigate the death in detention. And this was in 2003. And of course, nothing happened at that point. We also learned that by 2004, a secret task team had been set up in government with a view to looking at another form of amnesty for perpetrators of political apartheid-era crimes. And so when the TRC handed over its final report in 2003, we anticipated that what we would receive from the NPA would be prosecutorial guidelines. But sadly, in fact, we had to go to court to get prosecutorial guidelines. And of course, when they were published, they were merely another attempt to give perpetrators another bite of the amnesty cherry. Then, of course, after the amended prosecution policy had been launched, we had a number of families, including the widows of the Cradock Four, the family of Nakatula Simelane, and a number of human rights organizations actually taking the president to court in 2007 to really stop him using his discretion to give pardons, to give amnesty, to give perpetrators another opportunity at the amnesty opportunity. And in fact, on the 12th of December 2008, the Pretoria High Court found that the amendments to the prosecution policy were unconstitutional, and he described them as a copycat of the TRC's guidelines, which were not going to be exercised really by a committee like they had been in the TRC, but would be done administratively by the NPA, acting on the advice of officials. Around 2015, following years of engagement with the NPA to really begin to get them to move on the enforced disappearance of her sister, Nokuthula Simelane, Thembi Nkadimane was compelled to litigate so that she could get a prosecutorial decision on the 1983 disappearance of her sister. And what was really interesting about that was that we then had affidavits which were filed by the former head of the NDPP, Advocate Vusi Pikoli, and the head of the Priority Crimes Litigation Unit, Anton Ackerman, in which they both alleged that they were instructed by cabinet ministers to stop all work on the TRC matters. So already you get a sense of a special task force, and then you get the first hint of political suppression of investigations and prosecutions by the Mbeki regime. In 2018, following the decision to indict João Rodrigues after the successful inquest in the Timor matter, you had Rodrigues bring an appeal in the High Court of Gauteng to actually stop, to stay the prosecution in that case. And that is when we had a second opportunity to discover that, in fact, Chris McAdam, a senior prosecutor in the NPA, revealed that as far back as 2003, when he had met with the head of the Scorpions, he was told that there was a moratorium on the investigation of all cases and nothing more was going to happen. Now, in the Timor case, we've gone all the way up to the Supreme Court of Appeals. And in its judgment, the Supreme Court of Appeals really expressed its dismay at the political interference by the executive and the president at the time. And it actually said it was during this 14-year period, 2004 to 2017, that the executive adopted a policy position conceded by state parties, so an admission that the TRC cases would not be prosecuted. The court went on to say that it is perplexing and inexplicable why this stance was taken, both in the light of the work and the report of the TRC advocating a broad prosecutions policy, the guarantee of prosecutorial independence of the NPA, its constitutional obligation to prosecute crimes, and the interests of the victims and survivors of these crimes. And that is why what we have been communicating with the President and the Minister of Justice and the NPA is really to begin to look at this question of what lies behind the political interference, what lies behind the NPA not carrying out its constitutional obligation, and of course, why was the suppression of investigations necessary? Because I think a key question that has to be asked in the light of the fact that on both sides, you've had key alleged perpetrators dying. João Rodrigues died. You've had someone like Mr. de Klerk who's been implicated in the Craddock 4 case dying. And on the other side, even as we have a date for the trial of the first death squad to be indicted for the murder of Nokuthula Simelane, it is due to begin in May this year. Thembi's aunt, who is a critical witness, has also passed on. And I think that really raises the question of a further violation of the rights of victims to both truth recovery, justice, and accountability. There have been more than numerous communications between former TRC commissioners between 2019 and 2022. I counted the number of letters that we had sent. I think there were more than 7, to which we had very perfunctory, bland responses that the president had referred this matter to the Minister of Justice. And of course, when you look at the communications between the family members of apartheid-era victims with the president, they have also been dismally treated. And so what we are sitting with is an impasse in which the president refuses to engage on this issue. And at the same time, you have a complete delay, really, in the investigations and prosecutions. And this has an extraordinary impact on the ability of victims to access justice in our country. I will stop there, and I think Howard will take up the legal issues. Thank you, Hanif.
Thank you, Yasmin. Almost on time. Next speaker is Howard Vani. Howard Vani is an advocate in South Africa who represented a number of victims' families in a number of apartheid-era cases. He was also chief investigator for the Sierra Leone Truth and Reconciliation Commission, and he also acts as an expert on transitional justice in a number of countries, working for the International Center for Transitional Justice. Howard, you have the floor.
Thanks, Hanif. Good afternoon to everybody, and thanks to the Foundation for Human Rights and the Desmond and Leah Tutu Legacy Foundation for organizing this important event. Since the Desmond and Leah Tutu Foundation are part of this event, I thought I would kick off with a rather poignant quote from the late Archbishop Desmond Tutu, a statement that he issued shortly after the indictment was issued in the Nokuthula Simelane case back in early 2016. And as Yasmin mentioned, Nokuthula Simelane was an underground operative for the armed wing of the ANC. And in 1983, she was kidnapped, tortured, and disappeared. In other words, murdered. As Yasmin mentioned, we had to go to court in that matter to force a decision, which was eventually taken in 2016. But as we sit here today, we still haven't had a trial. And Desmond Tutu said the following that indictment. He said, "What has taken them so long? Why did the authorities turn their backs on the family of Nokuthula and so many other families for so many years? Why did the pleas of her family fall on deaf ears for decades? Why did it take a substantial application to the High Court to get the National Prosecuting Authority and the police to do their jobs? Why did the post-apartheid government take steps to obstruct the course of justice?" So it's really those questions posed by the Arch that are the subject matter of today's topic, which is the question around appointing an independent and open commission of inquiry into the suppression of the investigations and prosecutions of the cases that the TRC referred to the NPA. Now, I'm going to try to stick within the 5 to 7 minutes allotted to me. The organizers sent a list of 4 questions, and I'm going to try to deal with them each quite briefly. So the first question is, in your view, is the Commission of Inquiry the only option that will allow for the disclosure of the circumstances behind the political interference? In my view, it is the only option, because only an independent commission of inquiry appointed by the president, invoking the powers under the Commissions Act, will allow for an independent commission of inquiry to investigate with its own independent staff, lawyers and investigators. And as Hanif mentioned, and I don't want to repeat what he has said, only through a commission of inquiry can we have public hearings into what has happened. Only then can the public actually see what took place. Victims and their families and other stakeholders will be able to be represented by their own lawyers, who can put tough questions to individuals involved in the suppression. If it's an internal inquiry, none of that, or very little of that, will happen. And as Hanif alluded to in his introduction, we know from a speech given by the Minister of Justice, Mr. Ronald Lamola, at the Fort Kalata Foundation's memorial lecture in November last year. And he indicated that he had appointed an internal inquiry to investigate the suppression of the cases. He didn't mention internal inquiry. Of course, he wouldn't want to say that because that would be something of a swear word, so to speak. But he just mentioned an inquiry to be presided over by a judge. He had to be reminded that that would be unconstitutional. The law is clear. You cannot have a judge involved in an internal inquiry. He then corrected himself a little later to say, well, it wouldn't be a judge, it would be a retired judge. Now, in my considered view, I don't think that makes any difference to the matter. Now, it's becoming apparent that the reason why he is wanting an internal inquiry as opposed to a commission of inquiry is to avoid the kind of public scrutiny that would be directed to the issues at hand and to the personalities involved in the suppression of the cases. And the evidence we have suggests that it goes to the highest echelons of power within former administrations involving cabinet ministers, and presumably going all the way to the top of the South African government, certainly from 2003 for a period of 10 years and more. This, of course, is going to be enormously damaging to government, to the ruling party. And frankly, if it isn't going to be a public and open commission of inquiry, suspicions are going to run incredibly deep as to what is going on behind closed doors. And in an endeavor to deflect that kind of criticism, the minister tells us he's going to appoint a retired judge. I heard subsequently he said that he was going to appoint, he had asked Cato Regan, former Constitutional Court judge, to take up the offer, and she declined, in my view, quite correctly. I don't know the reasons for her decision to refuse, but I can only imagine what they were. In my respectful view, no self-respecting retired judge would take up a position to run an internal inquiry that was closed to the public, that would be enormously damaging to his or her reputation. Another reason why it has to be an independent commission of inquiry is that if it's an internal inquiry, you have a situation where members of the executive are investigating the executive. In other words, they're investigating themselves. So here you're going to have members of departments of justice, perhaps the NPA as well as the police, as well as other government departments, investigating their very own roles in suppressing justice and ensuring that hundreds of murder cases never saw the light of day. You don't have to be a legal scholar to understand how problematic that is. And simply having the gloss of a retired judge to try and give that an air of respectability is simply not going to wash. So the next question is, what is the legal basis for establishing the Commission of Inquiry? Well, the President has certain prerogative powers under the Constitution. He is free to exercise his power to appoint a commission under Section 84, sub 2, sub F of the Constitution. He also has the option of invoking the Commissions Act in order to give the proper powers to such a commission. And these powers would be the power of subpoena, the power to inspect and seize documentation and the like. And of course, ensuring that the commission has investigative teeth is absolutely crucial. Needless to say, an internal inquiry wouldn't have those powers. They would have to rely on the cooperation and goodwill of people and individuals implicated who could potentially have committed criminal offenses in suppressing these cases, not to mention the humiliation and embarrassment involved, are obviously not going to be coming forward out of the goodness of their hearts. The next question deals with the issue that and I think the minister and others have mentioned this, we don't need another commission of inquiry. We have, we're suffering commission fatigue with the State Capture Commission running for years, running over budget, endless extensions, costing more than R1 billion. Let's find another way. Well, frankly, and I'm sure we'll probably hear more on this from Lukanya, Tembi, and others. That's insulting to the families, because effectively government is saying they don't deserve a commission. We're going to give them something less, and I'll leave it to them to expand on that. But in any event, I don't believe this particular commission of inquiry can be compared to the State Capture Commission. There are extremely limited number of witnesses to call in this particular inquiry. Also, we're dealing with a limited set of facts. The inquiry into state capture and corruption was a massive inquiry involving literally hundreds, if not thousands, of cases and instances in which corruption and state capture took place. This is a very narrow investigation. So to raise that as a reason not to appoint a commission of inquiry is, with respect, completely wrong. The last question is, what would be the commission's mandate? In particular, would the commission re-examine the individual cases that came before the Truth Commission? No, the commission wouldn't have to be involved in investigating the cases that went before the TRC. That's not the role of the commission of inquiry that has been requested. Indeed, that's ultimately the role of the police and the prosecutors. They have to investigate those cases themselves. This commission of inquiry, and we have circulated terms of reference, it was annexed to the letter that was sent to the president, the last letter sent to the president, which was during the first quarter of last year. The mandate of the commission, the terms of reference, would be really quite limited and narrow. It would be to investigate how it was that the 400 very serious crimes that were highlighted by the Truth Commission, how they got to be suppressed, who was involved in suppressing those cases, what was the nature of the suppression, and what steps can be taken to ensure that this never happens again. It's simply quite extraordinary that in a post-apartheid constitutional order, where the independence of institutions such as the NPA are guaranteed, and only they may take these decisions, that they abandon their duties under law and under the Constitution so easily. This is one of the reasons why we attempted to ask the Zondo Commission to take this inquiry forward, because it amounted to the capture of the NPA and the police in relation to this category of crimes. And it's a matter of dire public concern. As Yasmin has mentioned, the vast majority of these cases can never be resuscitated. We're struggling to get cases off the ground because most witnesses, perpetrators, and family members have passed on. So it's an uphill struggle, and only a small fraction of the cases may see the light of day. So the fact of the matter is that the damage done to the families and to the country at large has been incalculable. The damage to the fabric of society and to the well-being of the victims and their families is extensive, to say the least. So this is a matter of great public concern. The very least we can do, since we simply cannot do justice to these cases, the delay caused by the political interference has killed off those cases. They will not happen. We're working hard to get a handful off the ground, but that's all we can expect. Those 400 cases, 98% of them are dead and buried. The very least that the families and the country deserve is to know why they were killed off. And only an independent, public, and open commission of inquiry can do this. Thank you, Hanif.
Thanks, Howard. We let Howard run a bit extra in terms of the time allocated because he had important things to say, and also because he can't stay with us right through. He's got other obligations. But let's move on. Our next speaker is Thembi Nkalimeng. Thembi is now the Deputy Minister for Cooperative Governance and Traditional Affairs, COGTA. He's also been Mayor of Polokwane. Thembi, together with her family, and I think one should mention both her mother and her father, fought for many, many years after her sister Nokuthula Simelane was abducted, tortured, and murdered, or rather we should say forcibly disappeared by members of the security branch in 1983. We have been pushing the NPA to make a decision about prosecution of the people who applied for amnesty for her abduction and torture, but not for her forcible disappearance. This matter is still dragging on in courts. Howard has alluded to it. We've even joined the policemen in asking for them to be funded in defending these matters. So without any further ado, I give the floor to Thembi. Thembi, you have the floor.
Thank you very much, Hanif, and good evening, I must say, to family, my family, which we have been in this struggle for long. Lukanyo, Galata, Yasmin, Suka, Howard, the Desmond, Leah, Tutu, Legacy Foundation, other family members who have been able to join us here. And thank you very much for the opportunity. Wow, Hanif, I don't know where to start after such eloquent speakers have tabulated the issues of importance, issues which are close to our hearts as members of the families, in our different stories, which all culminate into an injustice which has happened so many times, one under the apartheid colonized state, but subsequently post-1994 has been the second painful betrayal to our families. Because correctly so, we had an expectation that they were killed by the apartheid-era policemen, but policemen of today, policemen under freedom, will be able to assist us to bring their spirit to rest, but also to get the closure we so deserve as families. Nokuthula Simelane was a 21-year-old, turning 22 actually. University graduate. 2 weeks to her graduation, she was sent as part of an MK convoy to leave Swaziland to South Africa to establish what they were terming the VAL triangle network of Umkhonto weSizwe. In fact, Howard, in your remarks, you forgot that Dumankosi has also passed. Dumankosi is also one of our critical witnesses, passed away last year, November. Because he provided the safe house, he is the one actually who last saw Nokuthula in South Africa prior to her journey to Carlton Center, where she was to meet with Norman Mkonza, who was known as Scotch in the ANC. And the rest, we read it in history that he was a double agent, Scotch and lured into the basement of the parking area in Carlton Center. And she was subsequently arrested, taken to Norwood Police Station, kept for around 7 to 9 days, a week and some couple of days of early September, and then moved to Northam, a farm where on estimation she was kept for around 9 to 12 weeks under extreme torture. Guide gives us as given by witnesses who were police officers meant to guard her in the farm, amongst other areas, was that she underwent extreme torture. At some stage, she was unrecognizable, unbearable. She had lost her use of her splinter system, and she would urinate on herself. She would soil herself. She would be cleaned in the dam in such instances as part of the torture and submerged into water. But subsequently, she was moved from that farm, and the road looks like was leading back towards Vereeniging and the Western area. And that's where we lose trace. The late Frank Dutton took over. We were assisted as the family by the Foundation for Human Rights, which paid for the private investigation of subsequently what could have happened. And it led us to the Western area, and the safe houses, all the police houses which were used for torture were discovered. But guess what? We couldn't even use that private investigation. So in our painful story, the state denied us with an investigation. We were assisted to carry the investigation, submitted to them, but still not utilized to bring the matters to the conclusion. And we have then, after that, had a series of court applications, court appearances, forcing the state and the NPA to either investigate or to set aside the second bout of the TRC and the policy, which was possibly opening a window again for the police and the perpetrators. We went to court, we set that one aside. We went to court to compel them to bring the charges. We got that done. We went to court to declare her dead. We put that by the side. We joined the police, going to court to ensure that the police do get their right for the representation to be paid for by the state. We set that one aside. And we're on a journey. I think this is our fourth year now of postponement of the case. Hopefully it will sit on the 23rd of May. It has been a very difficult and a long road, emotional in some instances, mind-blowing in some instances, with a bit of some humor in some other areas. But it's a journey I wouldn't wish even to any family to undergo. And I'm hopeful that through such webinars, through such media exposes that we have continuously and periodically, some other families will be spared of the pain. Myself, Lucanyo, and others would have been the trailblazers in making their lives much better in the journey that they'll be undergoing. Of course, I must also indicate that there has been some recognition, awards which have been given to the family. I'm not overlooking them. But for me, for as long as I still don't have the complete knowledge of what happened to my sister, a statue that is proudly standing in the streets of a hometown, yes, I see it. Yes, I received the honor. But the greatest honor for her life would have been her life being marked in an appropriate manner. And as an African, and I guess everybody else, there is a way in how you close a life of a child, particularly the one who has chosen her people than herself. That the people whom she has chosen at a particular time, they need to stand up for her as well and say, we choose you because you chose us and you gave your life for us to be able to have the rainbow freedom and the rainbow country that we are talking about today, with its own challenges, of course. I think I will end there, Yasmin and Hanif, and say the last betrayal will be for the state not to put at the door the important cases that we need for ourselves as families, but not only families, as a country, to say what happened to your daughter, what happened to your son, as we close up and tidily put the cases to rest. Thank you very much for the opportunity.
Thank you very much, Tembi, for setting out what is really a painful episode and continues to be so. Our next speaker is Lucanio Lata. Besides being an award-winning journalist, he spent close to 2 decades pursuing justice for his father, for Lata, who was assassinated alongside Matthew Goniwe, Spero Mkonte, and Sicelo Mhlauli in June 1985. 36 years after they were murdered, he went to court to ask the South African Police Services and the NPA to finalize the investigation and to make prosecutorial decisions with respect to the torture and murder of what became known as the Craddock 4 activists. And this prosecution has still not started. I hand over to Lucanio.
Hanif, thank you very much. I want to just start off by saying what a real honor and a privilege it is for me to be invited to this, be part of this panel. Thank you very much to the Desmond and Leah Tutu Legacy Foundation, as well as to the Foundation for Human Rights. I am with someone like Tembing Kadimeng. Hearing her share her family's pain is usually something that I connect with so deeply. I've had the honor of meeting her on a few occasions, and it saddens me deeply that she, her family, my family, and so many other families have to deal with this issue 28 years into our democracy. Let me start by saying that on the 7th of July last year, the F.W. de Klerk Foundation issued a statement. And in that statement, they outlined or they mentioned a deal, an informal deal, but a deal nonetheless, that was entered into by former apartheid operatives and some ANC leaders. They had entered into this deal with TRC related cases. Now, the F.W. de Klerk Foundation would obviously know, or they do obviously know, a lot more than what we do about this deal. This deal between the ANC and former apartheid operatives was done in the dark. This deal was entered into without the consent of Talata's family. I am sure that this deal was entered into without the consent of the Simelane family, of the Timol family, of the Huate family, of the Mklenge family, of the families of the Kosas Four. I am sure that this deal did not have the consent of the Biko family. It did not have the consent of the Agate family. It did not have the consent of the Hafaji family. We can go on and on and on. So there was a deal made in the dark. It leaves us as the families with gaping wounds that continue to run blood today. It leaves us as families with unanswered questions as to why it is that a state for which our loved ones had died for will continue that practiced terrorist tactics against its own people. Because let us not forget, were a direct terrorist tactic by the government. To go after 4 young men from a small town in the Eastern Cape and murdered them so brutally. And in that brutality, to every other activist anywhere in this country that says, if you want to come and disrupt our power, disrupt our form of social engineering, disrupt whiteness, this is what we're going to do to you. We're going to kill in a way that sends a message to everyone out there. And not only did they kill them, but they also set in motion a plan to ensure that when they go to court, if they go to court, they would be able to successfully defend themselves against their actions. These are contained in documents. Nothing that I have said now is me just sucking it out of my. So there were deals made that were done in the dark. It's time for those deals to be brought into the light. And the only way that those deals between those former apartheid operatives and the ANC and some ANC leaders, only way that we can shine a light on them is through a public commission of inquiry. We cannot have another instance where deals that were done in the dark are now going to be investigated behind closed doors. We can't have that. We simply cannot have that. What we need now is for those deals that were done in the dark, for them to be investigated in the glaring light of the public, so that we as families can be able to see what goes on there, so that we have every opportunity. It is time. No longer keep us in the dark about its deals. And this is why we need and we are calling for this inquiry into why these TRC cases were not investigated. It must be a public inquiry. And the Minister of Justice must hear us, the President must hear us, everybody that have anything to do with this matter. There must be an agreement that the inquiry must be done in the glaring light of day. Thank you very much, Hanif.
Thank you very much for that, Lucanio. Howard has got another obligation, so I want to quickly pose this question to him. Just to remind everyone, any questions you have, please pose on the Q&A function. This is from Mary Burton, who was a commissioner with the South African Truth and Reconciliation Commission. She says that at a conference organized by the Institute for Justice and Reconciliation in 2001, one of the speakers, Professor Andre Dutoy, made a number of interesting comments and posed questions which may still be relevant today. He asked why, even at that time, we keep harking back to either or debates about accountability versus immunity, and wondered whether there was perhaps a secret deal about bilateral amnesty, or if not a deal, were there some talks or informal discussions. He suggested that an office or structure should be established where victims can get assistance, and indeed an office was established to deal with reparations of the different categories. Secondly, he suggested that a victims commissioner should be appointed in the president's office. Is that something which we might press for now, all these years later? I'll first open this to Howard, and then anyone else who would like to add to what Howard says, please raise your hands. Thanks, Howard.
Thanks, Hanif, and thanks to Mary Burton for that important set of questions. I'll deal with the question around whether there were these secret deals done to ensure that the TRC cases would be suppressed. And I'll leave it to the other panelists to handle the other questions and suggestions, which struck me as pretty good suggestions. The question around whether there were political deals hatched, perhaps back in the early to mid 1990s or even thereafter. This really is one of the reasons why we need an independent, public, open, and transparent commission of inquiry. The families, communities, and the nation are entitled to know why it was that the cases were suppressed. What is in fact the genesis for the suppression of these cases? That is a burning question that has to be addressed, and it can only be interrogated properly in an open commission of inquiry. If it's done behind closed doors, as Lukanya has eloquently pointed out, who's going to believe that the full truth was established when we didn't see the uncovering of that truth in an open and public manner? He's also pointed to the F.W. de Klerk Foundation statement that suggests that something was going on behind closed doors, and that people in the old dispensation were talking to people in the new dispensation as to what to do. We've also picked up information from those in ANC intelligence that around the time of our transition in the early to mid 1990s, and you will all recall that the torrid times we went through, the violence that unfolded through the early 1990s. Max Coleman, the late Max Coleman and his group, the Human Rights Commission, which became the Human Rights Committee, they were monitoring. They estimated that around 17,000 people died in violent political conflict at that time. And we know that there was a hidden hand behind that conflict, but that's another story. But some intelligence officials say that a deal was done between the securocrats on both sides. And they suggest that an agreement was reached, that the police and the army would intervene to stop the right wing and those neo-Nazi types from carrying out the bombings that they were doing, bombing supermarkets and the airports and so on. They would neutralize those threats, neutralize the threat imposed by the unholy alliance between the AWB in Carter and other groups. When a state of emergency was declared in KwaZulu-Natal shortly before the elections, the army agreed that they would go in and bring peace and order to that part of South Africa at that time. But the quid pro quo was, apparently, that there would be no follow-up. There would be no investigation of apartheid-era crimes committed by the military and the police. Now, again, I don't know whether there's any truth in that, but that's another reason why we need a commission of inquiry. We do know from the evidence of former NDPP Vusi Pikoli in a nighttime meeting with cabinet ministers and senior officials such as the late Commissioner of Police, Jackie Salebi, that he was told outright that he had to stop investigating, because if he carried on, he would open the door to cases against the ANC, and that was unacceptable. So there we have another reason why the cases were suppressed. But at the end of the day, as Lakanya powerfully said, all this has to be exposed under the glare and the scrutiny of the public. And this can only be done in an independent commission of inquiry that is credible and has the support and respect of the country as a whole. Thank you, Hanif. And unfortunately, I do have to depart at this time. Thanks again for the invitation. And I'm sure that you're going to have robust and fruitful discussion going forward.
Thank you very much, Howard, and thanks for making time available to us. I don't see any hands up as to whether anyone wants to add to what Howard has to say, but let me just ask the next question in the meantime. And I'll ask Yasmin Suka to address this one. This is a question from Bafana Kumalo. He wants to know, is it not possible to mount a public interest law class action of at least some of these cases against those known perpetrators who are still alive? This may compel a renewed interest by the NPA to fast-track the general prosecutions, I suppose. Yasmin, do you want to respond to that?
Thanks, Hanif. I was also going to respond to those earlier questions, so maybe just very quickly. I think it's really interesting that even though João Rodrigues died, and the appeal from the Supreme Court of Appeals decision on the Timor matter is pending before the Constitutional Court, we have seen an application from the generals under the organization Freedom Under Law, and they've actually applied under Rule 7.1 to be substituted for João Rodrigues. Now, maybe that's a publicity stunt, but in their application, they also say that they want a stay of prosecution on all of these TRC matters. And so what that does give one is a sense of the fact that the struggle for impunity is being now mounted by the generals. And I think when you look at the sort of slow pace of investigations by the Hawks, the kind of obstacles that the NPA have put in respect of all these cases, I think what you are going to see is the real battles around this question unfolding. There was a second question around whether a victims commissioner, I think, would be an important way of dealing with the question of reparations. And I think it's a broader question. I'm not sure if anybody knows, but we have 1.83 million in billions really in the reparations fund, and community reparations still has to be paid out. And the numbers of victims, I think more than, if they're about 16.5 victims and their families who've been paid out, there were 22,000 names submitted. And so there's a real question about what's going to happen to the funds in the reparations fund or the president's fund. And of course, there's been very little transparency on how that money has been used. And so it may well be that one of the things we should ask for is a special commissioner to deal with these issues, because otherwise it's currently administered by the Department of Justice. And if you speak to the South African Coalition on Transitional Justice, they will tell you of how little traction we've had over the last few years. And what we've been contemplating is whether there should be litigation against the state on this issue. There was a moment when, of course, the government wanted to use the money to bail out ailing ANC municipalities. And of course, the human rights community put a stop to that with families of victims, and of course, Kunamani as well. So coming to the question, I think you posed, the last one, on a public interest case, I think this is something that we have been looking at for some time. We're also looking at the question of filing papers to demand a commission of inquiry into the political suppression. But, you know, all of these things take time and money. And of course, it also brings its own challenges. And as both Tembi and Lucanio and many of the others where cases are sitting before the courts, I mean, we go back to May 2019, when the NPA was supposed to make a decision on the Craddock 4 case. You had an application launched in July last year. You had the NPA committing to making a decision on the 4th of December, and that date passed. And finally, through Lucanio and the family's efforts, one had the chairperson of the portfolio committee demand that the Ministry of Justice and the NPA appear before them to answer questions. But needless to say, I mean, we're now responding to the answering affidavit that the NPA has filed. And I can only tell you that it's such a pack of lies that you just wonder about the commitment to this question of justice and accountability. In the case of Nokuthula Simelane, which is due to go to court, we've been engaged in discussions with the NPA over the last 5 or 6 years on ensuring that the crime of enforced disappearance under international law as a crime against humanity is preferred against the death squad. And of course, they've refused to do that and are prosecuting it under the criminal law as murder. And what that does is, of course, it removes the question that this is a systems or political crime, and it's being treated as an ordinary murder. And so we don't really learn about the questions of command responsibility and the systemic nature of how the state engaged. And so all of these are very complex questions that we need to think about very carefully going forward. Thank you.
Thanks, Yasmin. Again, if any of the other speakers want to speak, please just feel free to raise your hands. I've got another 2 questions. I'm not too clear on these questions because they're not coming to me via Q&A. But let me just ask this one. Have the panelists given some thought to some possible arguments against a public, open and transparent commission of inquiry? And a further question, is the ANC reluctant to investigate the brutal murder of its comrades? Do you think they will support the call for a commission of inquiry in public, and especially as a number of core witnesses are dying? Thanks. So, Lucanio, let's start with you. 2 questions. The cons as regards a public and open, transparent commission of inquiry, why these matters were not prosecuted, and reluctance, supposed reluctance of the ANC to investigate these matters.
All right, cool. Thanks for that, Hanif. Look, I doubt that there are any cons to the truth being revealed. I don't think that the truth ever has a negative side to it, particularly when that truth is finally revealed. I think there are many things that were done here. For instance, who are those ANC members that entered into those deals with the former apartheid operatives? On whose mandate did they
Lucanio, you've frozen. It's happened before, but you came back quite soon.
Yeah, I
repeat the last.
Yes, I'm happy to do that. I think we need to know who these people are that entered in. gave them the mandate to enter into those agreements. We need to know who sent them, for what purpose. We need to know whether those people, where they currently sit within the leadership of our government today, and why exactly it was that they decide that they will make such agreements, that they will sell out my father for whatever nefarious reasons that they have. So all of that coming out is good for our country. It's good for us as the families. It's good for our country. But it's also good for justice in our system. It's good for reconciliation. So I don't necessarily think that there's any cons. I think that they literally are just pros to this inquiry being held in public. I think the second question, Hanif, was, is there perhaps truth to the rumors that the ANC leaders were perhaps also bought out in those discussions behind closed doors? Look, that's what we need to find out. You know, we don't know why it was that in the secret talks that Neil Barnard alludes to and all of those guys, we need to find out who agreed to any of those parameters that were set. Because the parameters that were set, the definition of what justice is, was not our definition of what justice is in those secret talks. Justice was defined by someone else for us. Now, having lost a father at the hands of the apartheid government, it can't then be the very same people who killed my father who come to define to me what justice is. It doesn't work like that. And when I say I'm talking about not just my family, but all of the other families who had lost loved ones at the hands of the apartheid government. But I need to define what justice is. Justice needs to be on my terms because I am the one who was adversely affected by what they did. So they can't be the killer, but also be the judge in this process. No, they did the deed. Now, me as the recipient, as the victim, as the survivor of their terrorist tactics, of their murders, of their maiming, of their evil, of their crimes against my humanity, I need to be the one that defines the terms of justice. Now, the ANC and whichever of its members entered into those agreements, they did not come to me to come and hear what my definition was. They simply agreed and said, okay. What they got out of it, we don't know. Were there business deals that were got out of it? Because within the space of 28 years, we've had people who were wondering what they're going to eat tomorrow, become multi-billionaires that own farms and estates and all kinds of things. Do those riches come from them having sold out? Are those riches paid for by my father's blood? Now, I don't want anything. My family's never asked the ANC for anything. We've never asked them for a tender. We've never asked them for any of those things. The only thing that we've ever asked them is for justice. Now, if the ANC cannot give us justice, then what good does it serve as a government? Because if it's not giving us justice, if it's not giving the people houses, if it's not giving the people healthcare, if it's not giving the people education, if it's not giving the people transport, but yet we see former ANC presidents steal 250 million rand in broad daylight to go and build his castle there in Gandla. If the ANC is not giving us what we want, what good does it serve us in government? Thank you, Hanif.
Thank you very much, Lucanio. Temi, you have your hand up.
Yes, I do, and thank you very much. I think I would like to add on what Lucanio has said, starting with the pros and cons. But specifically, because the question was directed at us as family members looking at the cons. Just as a reminder to everybody else, you know, the TRC terms were agreed upon without the input of families. And it was simple and straightforward. Now, it can't be that the rules of the games changes all the time and define others perpetually as victims. The country, led by the government, set up the TRC Act. Key to the act was that come forward, tell it all, and walk scot-free. So in this instance, Lucanio had no choice. If I killed his father, I would have been allowed to say, here I am, so and so, this is what I did under this tree, authorized by who, this is where I got the money, blah, blah, blah. Goodbye, Lucanio. Even when he's in absence, it was the country deciding the fate of what will happen for them to forge forward without even an input from victims. We were obedient. We went into those hearings. In some instances, not even properly represented. Yasmin knows that my family met its lawyer at the door on the second day of the hearing. So we were being represented, and you go to court in this example without having met your representative. That's how they did not regard us. Disregard. But we honored the part of our stick. They decide not to honor their part. So they violate for the second time the very same agreement and honor that has been given to them for free. Who must struggle again? The victim. Because it's the act which said, if your explanation is not found to be acceptable, you are not truthful, sufficiently, blah, 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 you will be denied amnesty and the cases will be referred for an investigation. We did not choose the judges. We had no say at all. Then we come with the outcome. We receive an outcome from the state, which says, in your case, we have wrapped up that they were not truthful in what happened to your sister, and your case must be investigated by the state. What are the cons there? What are the cons there, honestly? Because I do believe if the 5 perpetrators alleged in the case of my sister, having had gone to the TRC, by the way, one who passed did not even dare to apply. The late Musebenzi Khade. We only charged him when it came out that he did not apply and had a contribution in the kidnapping and the torture and possible knowledge of what would have ultimately happened to my sister. So why does it have to be information about us as victims in this instance, that we must be victims continuously, even when the law has been set by government and we did not violate it? But we also are the ones who must now, when the law is supposed to take its course, we go back to the victims and say, no, rethink again. Let's give them another chance. as if our emotions are on and off plug. You can switch them on, you switch them off the way you want. There's a comment from Spitle Ntswane, which talks about Bantu stands on the chart and homeland atrocities. There's quite a number of cases, actually, that Howard was talking about them as part of the 400. We know some few. We have a group of victims, and quite a number of families do come forward. I mean, I've been in Limpopo for over 25 years or so. I mean, in the old government of both Gazankulu and Libua, I know no less than 6 families who have approached me in person thinking I could be able to help. One had a brother who disappeared in Swaziland, was killed by the police, buried in Manzini, trying to apply for exhumation and even the identification of the grave, no assistance. And it has happened in a Bantustan. We know about them, but the question and the difficulty they are facing is the same that me and Lucanio is facing. They have knocked at the NPA door and no one is opening. So nobody is taking those cases. In fact, Kulumani, Yasmin may correct me, had over 800 listed cases of such people who came forth with the legal information that they had. And Marjorie Jobson's job was to write about them, try to source funding for them, try to create a dialogue between the state and those families so that they could be assisted. Maybe some did receive assistance. I've never heard of any. But the atrocities were all over. Even in our backyards, some we didn't know about them. But all of them are on the table. Unfortunately, all of them faces the same difficulty. Thank you very much.
Thank you very much, Tembi. All right, so we're going to end now unless someone has any final words that they want to say. I don't have any indication. Yasmin, you want to say something?
Yes, Hanif. I think that it's really important that we establish that, firstly, amnesties for serious international crimes are prohibited under international law. And so when South Africa adopted this policy of an amnesty, it was really seriously scrutinized to ensure that there would be safeguards or conditions put in. And of course, one of the reasons that it sort of passed muster was the notion of public hearings, the fact that families of victims could oppose it, and of course had the right to have lawyers appointed for them. But as Tembi points out, often the way in which this was done by the Amnesty Committee was fairly perfunctory. But of course, the most important issue is that the law provided that if you did not apply for amnesty, or if you were refused amnesty, then the law should follow its course. And that is why the TRC recommended a bold prosecutions policy and submitted a list of cases to the NPA for future investigation and prosecution. Now, of course, in the 23-year period since the TRC did that, it's instrumental. I think the families have played quite an instrumental role. Everything that we have had today, from the prosecutorial guidelines to each of these cases coming to court, to inquest being reopened, is because we've had to carry out private investigations using people like the late Frank Dutton, who did the investigation both in the Craddock 4 matter and the Simelane case, and of course, more recently, Clifford Marion. And it is only after litigation by the families against the state and the NPA that you have seen either an indictment or you've seen an inquest reopening. We've also consistently engaged with the ANC, members of the NEC between 2020 and 2021 around 2 issues: the need for a commission of inquiry that would investigate this issue of the suppression seriously. And secondly, the appointment of a special director with special staff supporting to really investigate the TRC cases. One that would bring the Hawks and the prosecution together, because this is the only way, if it is prioritized, that it will get any traction. Shockingly, when the NPA head appeared in Parliament, both she and her deputy said that in all likelihood, most of these cases will not be dealt with. And I think there's a huge question that we have to ask the state: who bears the responsibility for the further violation of the rights of victims, which they have under international law, according to many, many conventions, but also the basic rights and remedies which were adopted by the General Assembly in 2005, and of course in accordance with the Azapo case as well. And for each person that dies, and for each moment we move back on a particular case, you see the further victimization, not only of families, but also of our society, because we are entitled to know the truth about what happened in the past. Because if we want to ensure the principle of never, never again, we need to understand how these institutions were compromised and who is responsible. I see one of the persons in the audience is a courageous head of the NPA who lost his job because he actually did take steps to try and protect the rights of victims and ensure justice and accountability. And for that, he paid a major price. And I think we have to salute him for the courage that he showed when he took up these cases. Thank you.
Thank you, Yasmin. I assume you're referring to Vusi Piccoli. All right. Piyushi, you want to have your last word? Sorry, we can't hear you, Piyushi.
Thank you, Hanif. Hanif and colleagues, listening to this, it does make me want to pose the question of what kind of society do we want to be? Is I think perhaps worth foregrounding yet again. We've talked about strategies around litigation. There's a lot of talk in the president's opening this year with regard to a renewed social pact, and I do think that it might be worth considering getting quite forceful about what that kind of social pact would be. Clearly, the litigation processes are very important, but also to ask the question. I mean, for any open society, I think we're deeply cognizant that a social pact, a principle pact between government and the people can only be based on justice, can only survive on justice. So I'm wondering if, I'm also reminded of what the Arch said, is those who forget the past are doomed to repeat it, in terms of some of the opening perspectives that you've outlined, Hanif, at the beginning. With regard to taking this forward. That's the ringing voice of the Arch which came through in some of those discussions. So I just wanted to raise that, in order for us to make the call to be an open society rather than closed societies. And perhaps coming out of this conversation, we can make a powerful renewed call yet again. Thanks, Hanif.
Thank you very much, Piyushi. All right, so as we come to the end of this webinar, let's, listening to what Thembi had to say, let's remind ourselves that when the Act was being drafted, government and the opposition, which at that stage was the National Party, both want to have hearings in camera, behind closed doors. And it was civil society which sent delegations and opposed the secrecy that insisted and successfully insisted that all proceedings be public, with the exception of where there was danger to the witness's life, which was only a small minority of matters. So civil society ensured that we had this public airing of what had happened during apartheid. Let's remind ourselves of that when we keep pushing for this commission of inquiry. And we prefer not to litigate, but it seems as if the government or the people who are in positions of power only seem to respond when we take them to the doors of the court. So if we have to litigate, we will. But we call on people to support the holding of this commission of inquiry. We would welcome anyone approaching us for more information, and if they want to actively participate in this call for the commission of inquiry. And we will keep fighting for this until we see justice done. We've already compromised on the whole issue of amnesty. We are not willing to compromise further in terms of the rules that we made to allow people to take part in our society. Yet they still haven't been willing to come forward. So thank you very much for all the participants, the speakers, and you'll hear from us again. We're not going to go away. Lucanio, Tembi, the Imam Harun family, the Biko family, there are many of us. And as Tembi has pointed out, there are many of us whose names we don't even know. But we do know what had happened during apartheid because a lot of us lived through it. So thank you again. We'll keep fighting the good fight and we will not give up. Until you hear from us again, please contact us for your support. Thank you very much.
Thank you.
Thank you very much, everybody, and have a great afternoon.
Thank you.
Thank you.